I'm Colin O'Keefe, and today on LXBN TV, we are taking a look at the Supreme Court, what they're hearing now, and the new cases being granted cert. Joining me to discuss is someone who knows a thing or two about the Supreme Court. It's Archis Parashurami. He is co-chair of Mayor Brown's Consumer Litigation and Class Actions Practice Group and author on the firm's blog, Class Defense. Archis also was one of the lawyers who represented AT&T in 2011's big AT&T Mobility v. Concepcion SCOTUS case. Archis, first, let's start by taking a look at what the Supreme Court is hearing now. What's caught your attention there, particularly as it pertains to class action litigation?
Thanks, Colin. So I am really focused on class action defense, and just yesterday, the Supreme Court heard oral arguments in a case called Mississippi XREL Hood versus AU Optronics. The underlying case involves allegations of price fixing, but the legal question presented to the Supreme Court is whether, when a state attorney general brings a lawsuit seeking to bring claims essentially on behalf of its citizens, whether that case can be removed to federal court under the Class Action Fairness Act. And this is an issue that has divided the circuits. So yesterday's oral argument it was a very interesting argument, but it's hard to say how the case will turn out. The questions were pretty hot and heavy on both sides. And, from my perspective, what's interesting about these cases is that they look like and quack like class actions, so why shouldn't they be removable like class actions? And certainly there were some justices on the court who saw that same sort of policy way that I did. But there are other questions about whether this really fits within CAFA's definition of a mass action. And so this is definitely a case to watch. It was a very interesting argument to attend.
Absolutely. Of course, with these oral arguments, you never know exactly how big of an impact they're going to have, how much they're going to sway the justices' pre-existing opinions on the case. And then second, let's look forward. What's caught your attention as far as what's being granted cert by the Supreme Court? What stood out to you there as far as being interesting or being particularly impactful?
So right now we're waiting on a number of potential cert grants in a number of cases that might affect class actions. Let me mention a few issues. One is a case in which our firm is involved, and I'm not commenting on behalf of our clients or anything, but my partner Josh Yemp wrote a blog post about a pair of cases that the firm is doing for Whirlpool and Sears relating to whether it was proper to approve class certification in the so-called washing machine cases. And there's a situation where many members of the proposed class have not experienced the alleged defect manifesting at all, and yet the courts of appeal upheld class certification. And so the petitions raise some very important questions about the appropriateness of class certification in those circumstances. And anybody who's interested, the petitions are on our blog. They're, I think, obviously I'm biased, but they're well worth reading. The second issue is one where there was actually a denial of cert earlier this week that I wrote about on the blog in the case involving Facebook's Beacon settlement. And the facts of the case, I think, are less important, especially since cert was denied, than what it means for future class actions. This was a case where the cert petition challenged the fairness of the class settlement, where the payments would have been made on a cypre basis. That is, money wouldn't have gone to class members. Instead, the money would have gone to charities. And so the question that the cert petition raised is whether a class settlement is fair under those circumstances. The Supreme Court denied cert, but in a pretty rare statement about the denial of cert by Chief Justice Roberts, the Chief Justice said that he was interested in these questions, and he listed a number of subsidiary questions, both about how cypre works in practice, cypre settlements work in practice, as well as whether the entire enterprise, at a fundamental level, is appropriate. And it turns out that a lot of class actions today do settle on a cypre basis. So if the court grants that issue in a future case, and the Chief Justice was delivering a hint that he's looking for such cases, then, at least in my mind, that's something for practitioners in the class action space to be watching and thinking about as they settle their cases. And then the last thing I'd mention, you had mentioned Concepcion at the start of this, and since Concepcion in the 2.5 years, there's been a ton of litigation about what does that decision mean, what is the reach of the Federal Arbitration Act, and to what extent does it preempt state law. By far, I think most courts have been taking the view that arbitration agreements should be enforced, and when the consequence of that is to require individual arbitration rather than class actions, that is appropriate. But some courts have, at least in my mind, been resistant to Concepcion, and we've seen a lot of that in a number of state courts and the Supreme Court in a number of cases, at least 3 cases since Concepcion, including one where we represented the petitioner, summarily reversed the state court. So one would hope that the state courts would get the message, but not every state court has. And so I predict that there will be some cert petitions coming up that raise that issue of when state courts have been defying, at least in the view of the business community, the Supreme Court's dictates in cases like Concepcion, whether the Supreme Court should step in. So that is an important issue that's worth watching.
Absolutely, absolutely. These are all cases worth keeping an eye on, and for people looking to do so, they should be sure to swing by your firm's publication. It is at classdefenseblog.com. And of course, again, that was Archis Parashurami. He is with Mayor Brown. For more of our video interviews from lawyers like Archis and curated commentary from the LexBlog Network's more than 8,000 members, be sure to swing by lxbn.com. Thank you for joining me today, Archis.
Thanks, Colin. I enjoyed it.